Good afternoon, everyone. Thank you for joining us for the NASW New York C.A.R.E.S Community Engagement Initiative for the second NASW New York Private Practice Spotlight, How to Start a Private Practice with Dan Pepitone. These spotlight events are standalone non-CE events designed to support those in private practice or considering starting their private practice journey. My name is Angelique Imani Rodriguez, and I'm the manager of membership engagement and special programs with the NASW New York chapter. I'm so happy to have you all here today. Excuse the outlook noises. We appreciate your attendance and support of NASW New York chapter programming. Registration for the upcoming first annual NASW New York CE conference, where you can earn up to 7.5 CE contact hours, is still open for registration. There's non-CE student sessions if you'd like to join us, but don't need the CE contact hours. A hybrid format conference, you can join either in person or online. You don't want to miss out. Registration closes on May 15th. We have a robust calendar of C.A.R.E.S programming, including next week's senior series, which is a set of events created to support elders and the social workers that serve them. In May, we have 2 joint town halls with 1199 SEIU on pay equity and an incredible immigration series hosted by the NASW New York Immigration and Global Social Work Collective. Additionally, we're still accepting submissions for the spring-summer 2026 issue of the NASW New York Currents newsletter until May 6th. This issue, the theme matches that of our conference: One New York, One Voice, Reimagining Social Work for a Just Future. I do hope to see some submissions from you, and yes, I do mean you. Post-event, you'll receive an email that will share all of this information about what's upcoming at the chapter, as well as any resources or information provided by today's hosts. Please remember that by registering for any NASW New York events, you agree to abide by the NASW New York anti-harassment policy, the link of which I will drop in the chat for you all shortly. Once again, thank you all for joining us today. If you have any questions about this event or any other NASW New York C.A.R.E.S community engagement events, I'll drop my email in the chat for you shortly as well. Without further ado, let me introduce you to our host for today, Dan Pepitone. Dan, whenever you're ready, please feel free to unmute and begin.
Cool. Thank you so much, Angelique. You've been so awesome throughout this process, and even just having me, I feel really honored. I'm excited to talk to you all today about getting your private practice started. Thank you so much for being here. A little bit about me. I'm an attorney. I've been one for 19 years. I previously worked at a nonprofit law firm where we provided free legal services to people who couldn't afford lawyers. Initially, my practice was focused on people living with HIV. That turned into a wider LGBTQ focused practice, always with a big overlap of people with severe mental health concerns. So through that work, I did a medical legal partnership at the Callan Lord Community Health Center for like 8 years, where I worked very closely with their mental health department and care coordination teams, and learned a lot about what you all go through on a daily basis and how intense it can be and complicated, and yeah, really amazing work. So I've always been very into that. And when I had the opportunity to leave my nonprofit job of 14 years, I went into private practice with a goal of supporting you all in your private practices. So now most of my clients are mental health professionals in private practice. It's like, I don't know, 80–90% of my work. I also help other licensed professionals set up their practices. And then I have all these kind of like do-goodery type consultants, which is really cool. But for you all, I do a lot of the same stuff on repeat, like PLLC formation, client documents, employment agreements, a bunch of other things that are kind of so routine. I have a flat fee schedule for it. And then I also provide people with advice and counsel. In theory, this is about a whole wide array of things, but it tends to end up being mostly about more urgent things like a complex client termination or a subpoena request. So I'm available for those kinds of things. I don't do disputes between therapists, and I don't represent people in disciplinary matters or malpractice claims. But I do have referrals for other things. There's other things I don't do kind of further outside the general scope of running your own mental health private practice. But I'm happy to provide referrals when I have them, which is a lot of the time. Today, we are going to talk about starting your own private practice. I'm going to run through a guide that I have on my website as kind of like my outline. And I'm going to share it. I'm going to put it in the link now in case anyone wants to just open it up and kind of thumb through on your own as we go or later. I do try and put a lot of resources on my website. One of the biggest things for me getting started in this work was kind of the shock of how difficult it was to find answers to questions and sort through this, wide array of regulation. And so I do try and update my guides and let people know important things and sort of create like a starting point for people who are just getting started or are operating a private practice. I'm going to be sharing a lot of information. It's not going to be advice. Even when we get to like the Q&A, if I answer questions, it's really important that people consider their own situation individually. And every situation just is so different. So if it's appropriate to speak with a lawyer, which oftentimes it might be in some of the topics that we're going to cover, I really encourage you to do that. Obviously, you can reach out to me or somebody else as well. But for the purposes of this is really information. If any examples are given, they're really examples, and you have to think carefully about whether your situation really matches that. So dead on. So I am going to dive in, and I'm going to start by sharing my screen. I'm just pulling up my guide here. Common issues for behavioral health private practices. I gave you a little bit of the disclaimer. That's just kind of like the written version. This is another training I did like last year or something, if anyone ever wants to watch that. But I believe Angeliki is going to share this and perhaps put it on the YouTube page, which will be cool. So yeah, the starting point for people is making the leap. Maybe you work at an institution, you work for another private practice, you've completed all your hours, or you're really close to doing that. You're close to full licensure, or you're fully licensed. So now it's time to go off on your own. I created a guide that I link to here on starting a small business. And I just go through some initial things to think about, creating a business plan, thinking about finances, thinking about like the tools and programs that you might use. So I encourage you to go through that a bit. I do really like the idea of people creating a business plan. Not that it has to be some like, perfect like every detail accounted for. But I think the process of reviewing what a business plan has, like marketing and how much money you're going to spend, how much overhead you have, are you going to meet people in person or online only, kind of just gets you started on thinking through these issues. So I really encourage you to do that. SCORE, which is a program through the New York Public Library, has a really good like list of templates that people could use. And again, you don't have to feel really overwhelmed by it, but if you kind of just look it over and maybe make like a little kind of outline and run through those things as you think of them, I think that can be really useful. I also include some books that I find really useful, like The 7 Habits of Highly Effective People, which my clients know that I am always citing the 7 habits. I love the 7 habits. And another great book on negotiation called Getting to Yes. Those are linked at the bottom of, I believe it's that guide. And in case people don't know about Libby, Libby is the app through the public library where you can take out audiobooks for free. It's really cool. I love Libby. When I go on like long car rides and stuff like that, I'm always getting books off Libby. So if you don't know about it, check it out. Um, so yeah, the first step then is to think about what entity options make sense for you and make sense for your private practice. One of the biggest things, and this is a really hard thing, like maybe once every week or two, someone comes to me and unfortunately, they've created an LLC instead of a PLLC. An LLC is a limited liability company. The idea is that you're creating this separate business entity that gives you protections, protects your personal assets from the debts and obligations of your company. It's really important to know that for professionals, you need a professional limited liability company. You're not supposed to practice your profession under a regular LLC. So you form a professional LLC, which is just a type of a regular LLC. Functions much like the same way, but now you are, making sure that you're approved and have the authority of the Office of Professions to form this business and to practice your profession under it. Um, I have a guide to forming a PLLC on my website too, which I link to here. We can talk a little bit about that. Unfortunately, it is a pretty complicated process. You are dealing with the Office of Professions first, getting a certificate of authority from them just to even, like I said, run your practice, practice your profession under your PLLC. From there, once you have the certificate of authority, you go and you file your articles of organization. These are like the formation papers with the Department of State, specifically the Department of Corporations. They approve it at some point. Usually it should be really quickly if you request expedited handling. And a few days later, your PLLC is formed. At that point, you still have other things to do. You're supposed to publish notice in two newspapers that your PLLC was formed. It's just like a little blurb in the back of like the public notices section of newspapers, now very much done online, as you can imagine. New York is the last state, as far as I know, that requires this. We'll see how much longer it goes on for. In addition to publishing notice in two newspapers, you get an EIN, you deal with your NPI, you set up bank accounts, credit cards, that kind of thing. These are really, really important things for you to consider and kind of get your ducks in a row. You'll see in my guides, I run through these like very basic requirements. So I do encourage you to check those out a bit and see how that works. I'm focusing right now on PLLCs, but there are other options for people. To me, PLLCs are the simplest. In theory, an LLC in general often makes sense for people because it's the most flexible and not as rigid in terms of all of the like reporting and regulatory requirements that a corporation has. So generally, the two business entities that people go for are a PLLC or a PC. A professional corporation like a PLLC kind of works in that same way, where it's just a type of a corporation. But again, you can't practice your profession under a regular corporation. So you start a PC, but there's some kind of extra requirements, and it can often be a bit more challenging for people. But those are two of the bigger options. There's also limited liability partnerships. That can be a thing as well. You may also decide not to form a business entity at all and operate as a sole proprietor. So you do not need a separate business structure in order to operate your business. You can operate just in your name. You sign contracts with clients, with your EMR and that kind of thing in your own name. Generally, I think that this can be okay in a lot of situations, but you don't really know the course that your practice is going to take. If you have plans to hire employees or rent office space, it usually makes sense that you have this business structure and that you're keeping things separate between your business and your personal life. If something happens and something goes wrong, your personal assets, your money in the bank, property you own, could be on the hook for responsibility for these debts or obligations that you now have personally. That's why we like to create this shield with a business entity. It's one thing just to create the entity, and it's another to really like effectuate this difference between the business and yourself. So it's very important that you not like commingle things, money in particular, but that you really keep your business side of things separate from your personal life. Another thing that I just want to point out is that Having a PLLC or a PC doesn't shield you from malpractice claims. That's kind of the exception. That's where you have malpractice insurance. Where an LLC or a PLLC is useful is with like other contracts or like conflicts you might have in other realms of running your business. In particular, let's say with like renting office space, where sometimes that can be a challenge, particularly in New York. So that's a little bit about just like the entity structure itself. I think it's really important that people do consider their particular circumstances, speak with a lawyer, consider what your options are. I'm sorry, another thing that I will just touch on too is S corporations or S corps, which I know like really gets put out in the world. My Instagram thinks I'm a mental health professional in private practice. So I'm always getting like S corp this, S corp that, and I kind of see what you guys experience in a lot of ways, I think. But an S corp isn't like another type of business entity. It's not like PLLC, PC, or S corp. What an S corp is it's a separate um, classification for tax purposes. So for the IRS, when you have a PLLC, I'm going to start there. You are treated as if you have no business entity for tax purposes. It's considered pass-through taxation. Your PLLC is considered a disregarded entity, so you don't file a separate return for it. You report your revenue, you report your profits, the money you're bringing in, your deductions for business expenses like your EMR, your malpractice insurance, and that kind of thing on a separate schedule on your individual or jointly filed return, a Schedule C. When you have an S corporation, now you are being treated as a corporation, an S corporation, instead of a disregarded entity for tax purposes. The reason a lot of people might elect to do this is based on their financial situation. It may make sense for them to file as an S corp, and then they have this reduction in the self-employment tax. Your self-employment tax, like when you're taxed when you're working, is for Social Security and Medicare. When you file as an S corp, you're treated not only as an owner, but also as an employee. So now the amount you're kind of like taking as profit might go down because now you have this salary. And so your self-employment tax goes down, and that can be appealing and also makes sense for other reasons. It makes sense for you to speak to an accountant to really understand your specific financial circumstances. I get a little nervous when people are just like right away off the bat, like 100% all in on an S corp, when I'm not really hearing like the full appreciation of like how it's going to help them and the other requirements that you have when you file in this way. Okay, so now your business is formed somehow in the 10 minutes I've been talking. What a dream that would be. Doesn't really play out that way. And so we're going to think a little bit about the things that are happening to you, in particular in the beginning of getting things set up. I have a guide on my website that covers your basic legal maintenance activities and requirements that, of course, I encourage you to check out and review on a yearly basis to kind of see, are you staying in line? Do you have kind of all your ducks in a row, and that kind of thing. So check that out in your own time. I have this list of what I consider to be important practice documents. And of course, the first and foremost are your documents for your specific clients as they're getting started with you. So, like your client policies and procedures is an important thing. This often gets grouped into an informed consent document. I just want to point out that informed consent, when done in writing, really should be its own standalone document. So you introduce the treatment that you're offering, the pros and cons, the alternatives, and then the client is giving their informed consent for that specific thing. I don't like to see a client document that has the informed consent and then also all these other, rules on cancellations and other things. That really shouldn't be. It should be a standalone document. But for your policies and procedures, you might put things in like how communication works, information about you and your licensure, information that clients have a right to make complaints if something's going on that they're not particularly happy with or they're concerned about. Communication, like I said, billing and payments, emergencies, urgent issues. What happens if something happens to you that someone might contact you? We'll get to that a little bit more. Cancellations, terminations, all sorts of things that help you establish from the get-go how you operate and also act as like your first list of guidelines for you, how you handle these situations when they come up. So to me, it is really important to have a thoughtful list of your policies and procedures that's very clear for clients. I included this informed consent for video conference sessions, which is also a requirement. You want people, like I said earlier, to say they really understand the risks and benefits to using these. Unfortunately, there are risks, of course, to using video conference where someone could hack into it, that kind of thing, privacy concerns. I actually don't have on this list, which I just realized now, and I'll add it after I get off. But if you're using artificial intelligence technology, it's definitely important to get people to understand what that is. And if they're consenting to it, that they give this written informed consent. There are a lot of new services just coming up all the time. And so I encourage you to be thoughtful about, what's involved with that, what the risks are, what's really necessary for you, how you operate with, your understanding of your duty to protect your clients' protected health information, this duty of confidentiality and privacy. We have your notice of privacy practices, which I'm sure you've all seen a ton of times in many different ways. I think it's important to tailor yours to the work that you're doing and really consider, what's going on with your specific work, what the situations are where you might need to reveal someone's private information, their protected health information, without their express authorization, whether it's an emergency or you're concerned about someone, there's, a threat of imminent harm. These are things that it's really important to flesh out and think more concretely about how your practice works. And the instances like laying out what their rights are, their ability to get records, what records you might not reveal, like psychotherapy notes. Good faith estimates. If people don't know, Congress passed an act a few years ago called the No Surprises Act, which, seemingly was geared more towards doctors and hospitals, where we wanted consumers to know how much they could expect to pay instead of getting a giant bill at the end, that they would be given an estimate in the beginning. So this is a requirement that also applies to you all for clients who are not paying with insurance. So if they are directly giving you money, even if they're getting reimbursed by insurance, all of your clients need a good faith estimate. And it's important that you do it at the beginning and that they always have an active one. They can only last for up to a year. So you might need to review annually or more frequently as, this situation allows for. Maybe you have someone start and you just do like a 3-month thing because you think they need more intensive treatment until you start out like weekly or whatever you think is going to end up working for them. So consider that. There is a mind-blowing article in the New York Times today about abuse around some other provisions in the good faith estimate law that I encourage you to check out because it is truly unbelievable. And does not impact mental health professionals because it's a kind of different segment. You have requirements in New York to tell people that they have rights under like how they pay you. If they end up using a credit card to pay for services, this takes them out of their rights if they have medical debt. And New York is sort of in this phase of like changing these rules around getting people to have a consent to pay for services and for you to give people a notice of the risks of using a credit card, namely that now they won't have the same protections for healthcare that they otherwise would have. Now this debt is treated as credit card debt. I have two guides or a guide on my website that covers these two issues, which I encourage you to check out and look out for updates for because this is a very influx situation right now. You all are likely familiar with your ROIs, your authorizations to release information, important thing to have right off the bat. Your website notices and terms and conditions. For your website, you have some things that are required for your clients and some things that are required for all users of your website. Anyone who clicks on it, you should have a terms of use and a privacy policy. And this is really important to consider with your specific situation, how you're using your website to make sure that your terms match the usage there. If you're hiring people, of course, you're going to have some kind of agreement with them, whether it's an employment agreement or a contractor agreement, which we'll discuss more, and then policies around their work with you. So, with the distinction between employees and independent contractors, which I know has been talked about very widely in the industry, this is a really tricky thing. A contractor really is someone who is coming in with like a really specific purpose to perform certain services on behalf of the practice. For the most part, I would consider someone who is providing psychotherapy services that their proper classification would be as an employee. There might be some reasons in individual circumstances with this where this isn't right. But my point being that if you're going into private practice, you're planning to have a group practice, it is very, very important that you understand the implications of misclassifying someone. If you misclassify someone as an independent contractor when they should be classified as an employee, you run the risk of penalties and owing like back benefits, whether it's workers' comp insurance, unemployment insurance, other things like that. You could run into issues with some of the agencies that govern these benefits and taxes in general, the IRS in New York State. So that is an area that I encourage people to take very thoughtfully, to move forward through it very thoughtfully. So I have a guide on my website too to identifying whether someone is treated as someone should be classified as an independent contractor as an employee, which I encourage you to check out. I also have a guide to your responsibilities as an employer in New York, which is quite overwhelming. There's a lot of responsibilities. So you might try and like do a quick skim of that and then take it in bite-sized chunks. It can be a little overwhelming. There are plenty of guidelines on supervision that I encourage you to check out to make sure that, if you're running a practice, these are clients of your practice and you want to make sure that you're properly supervising the providers who are giving them care. So look into that a bit. Switching now to liability issues, things for you to consider. There are issues with scope of practice, in particular, that I think people really need to be aware of. We know that there's all of these different professions that are doing similar work, and there are lines drawn between the boundaries of these professions. So it is really important that people stay within the boundaries. Mental health counselors are in a difficult situation right now with the diagnostic privilege and the impact that's having on them in various ways. So, if they don't have this diagnostic privilege, they're not supposed to be diagnosing clients. For LMSWs and LCSWs, there's work that an LMSW can do on their own independently, but they can't provide clinical services. So it's important to really be aware of this distinction, particularly for LMSWs who are trying to go it alone. The Office of Professions does not allow an LMSW to work independently and then hire someone for supervision to satisfy their hours requirement. So this can be really complicated, and I think it's really important that people are really careful about the work that they're doing and just know what the boundaries are in their services. Obviously, there's other issues like dual relationships, other services being provided to clients, and that kind of thing, which should be very carefully considered in everyone's individual circumstances. There are just a little bit, there is information here about the penalties involved if someone's practicing, outside the scope of their practice or without a license. I have some information on the professional rules of conduct and ethics. The NASW does a great job of having a very easy to read and follow and sift through code of ethics that I encourage people to check out too. And the NASW provides a lot of good guidance too, which is great. So always a good place to begin your kind of review of your ethical guidelines. Some issues around privacy, confidentiality, security, and disclosures. I have a guide on my website to telehealth rules and best practices that you might check out to just kind of clean things up, make sure you kind of have your ducks in a row. But beyond that, I really encourage you to check out the website Person Centered Tech. They're great. They have so many good resources. They are so on top of these issues. And they're just really nice people. So you might check that out, and it can be a good starting point, particularly for people who are going to have a group practice. I think it's extra, it's that much more complex to have all these other people make sure that they're following all these guidelines, and person-centered tech can really help people get on the right path there. I kind of discussed your notice of privacy practices before. Um, Again, telehealth is listed here in particular, rules around it. I also have guidance on device security and protecting confidential information of clients and some very basic tips of, having password protected devices and that kind of thing. That at least I think is a good starting point for people as you start to explore how to best protect your clients' information. All right. A big issue that comes up a lot is this idea of practicing across state lines. So this can be a really tricky thing if you're licensed. New York's rule is essentially that if you are licensed in New York, you do not necessarily need to be physically present in New York to work with your clients, let's say by telehealth, but your client is what matters. It's mostly about that your client resides permanently in New York, but there is a lot of issues about like how often they are in New York. And this might be a real case by case issue if you have someone leaving the state for, certain periods of time that you're going to want to consider. It obviously gets more complicated too as we start to think about like, other states' requirements for seeing their residents. It's important to always check the rules of other states. Even if your New York client is going to another state, you might look up what the other state says about that. Some states have like limited permits, so maybe your client is there for an extended period of time, and then you're able to see them for that extended period of time thanks to this limited permit. So things to be a little bit thoughtful about. I think New York's rule, is somewhat clear that it really is about where the client is. where the client is located, where the client resides. And I think most states are following similar rules, but it is always going to be important to check out the rules of other states. I didn't mention this earlier, but I am focused on New York. I am only licensed in New York. So while a lot of the things we're talking about may apply in other states, it's very, very important that each state that you're licensed in, that you understand the regulations and rules for having your private practice in that state, including foreign entities. So if you are engaged in business in another state, in any business, the general idea is that you are supposed to register your activities, register your business with that state. So, a common way of this happening is you form your PLLC in New York, and then you are also licensed, let's say in New Jersey or Connecticut, and you want to engage with clients who are living there. And the idea is that those states would require that you are properly registered with them there. And the way to do that is register your PLLC, your New York PLLC, as a foreign entity in the other state where you're going to be seeing those clients. Um, you have specific requirements too when you have in-person operations. I think it's important for people to consider what's involved with that, starting with an understanding of commercial leasing in New York. I think more and more people are subletting from somebody else or subletting from one of the businesses that, rents out office space by the hour, the day, the month, or whatever it is. And it's not like a full commercial lease. Either way, I think it's important to understand a little bit about how these issues work. You are still, even if you are not directly engaged with the landlord, there is still a New York landlord involved in that. Very important for you to get malpractice insurance and make sure that you're always maintaining it when things change in your practice. If you're adding another state, if you're adding an employee, that you really understand what the terms of your policy are to make sure that you're always staying on top of that. Another good thing, to check in once or twice a year to see that everything's in line there. There may be other insurances that you consider, like cyber insurance in case there's like a breach or a hack, which used to be much more expensive and now is a bit more affordable. I have some just guidance on making sure you really understand your policy. So, what situations are covered by it, what situations are excluded, what your responsibilities are for cyber insurance. Sometimes you have like very rigid guidelines of the protections that you need to be taking in order for them to jump in on a claim that you make. You might also consider other insurances around, having employees, having space. If you are renting office space, you might get general business liability insurance that would cover personal property damage, like if someone loses something, loses their purse or something, and personal injury if someone has like a slip and fall in the space that you're renting, making sure you're covered. I knew it. I have more guidance on good faith estimates here. It shocked me above when I had it and it wasn't highlighted with the link, but it's here. You can find more guidance too from the APA and the NASW on good faith estimates, which I encourage you to do. They have really good resources. One of the important things that I understand really can be overwhelming to people, but you have a continued obligation to provide access to records for clients even after something happens to you. If you are incapacitated or you pass away, you need to make sure people can still access their records. And even more than that, that they have continuity of care, that they have referrals, that someone steps in and contacts them to tell them of the situation and helps identify appropriate care moving forward. So I encourage everyone to consider and complete a professional will. You don't need a lawyer for this. It doesn't need to be notarized. I have a guide on my website with more information on some of the requirements around a professional will that I encourage you to check out. I'm going to kind of skip over management service organizations, which can be a complicated thing. It's not something that I handle, but that is, yeah, an industry and something that you might engage in that really has to be done thoughtfully. The idea being that you're going to like provide back end support to other practitioners. New York has a bar on fee splitting. So if it's someone outside of your practice, it's not an employee, you are not allowed to split the fee like a referral kind of situation with them. Important to talk to an accountant, like I referenced before, about your financial situation and your taxes and that kind of thing. So I very much encourage people, even if you're going to work on your taxes and finances alone, it can be helpful to reach out to a few people to better understand how that works. But I do not think you need an accountant necessarily, but to get specific guidance about your situation, it can be a good starting point. And then, yeah, finally, just to reiterate, we just went through a ton of information. When, things come up, you can reach out to me, reach out to another attorney, and that could be a good place for you to start to deal with your issue. And I'll turn it back over to you, Angeliki. Maybe we'll go through the chat
Yep.
a little bit and
We have
open it
a
up.
few questions in the chat. The first is if you have malpractice insurance in your name as a sole proprietor and later get or become a PLLC, do you have to re-register or repurchase your malpractice insurance under the PLLC name?
Yeah, I very much encourage you to reach out to your malpractice insurance provider to understand exactly how it works for them. But the idea is that you're doing business, you're engaging in your profession in the name of the PLLC now. So the PLLC should be covered as well as you as an individual who's providing these services. In particular, if you're going to hire employees and that kind of thing, you really want to make sure your insurance is covering everyone. But reach out to your malpractice, sooner than later to just understand how that change might look.
Another question is, can you keep liability insurance from NASW in New York State if practicing with New York State LCSWR from another state? Also, okay, that's a question for me. No, my suggestion would be to join your local chapter, though you can always come to C.A.R.E.S events and you can always engage with the New York chapter, of course. But the first part of the question, I believe, would be for you. Can you keep liability insurance from NASW New York State if practicing with New York State LCSWR from another state? I'll get you that information directly, Rachel, around the NASW insurance. Also, you mentioned a PLLC and what it is versus a S-Corp. Is it okay to keep practicing with just a DBA?
You can operate as a sole proprietor. We kind of went into this earlier, so I'm not going to repeat like every part of it of, these benefits to having an LLC, keeping things separate, protecting yourself. One thing that I kind of didn't hit actually when I was talking about S corps though is when you have an S corp, it's not a separate entity from a PLLC. You might have a PLLC, then is classified as an S corp, and you change your classification for tax purposes. But yes, you can operate as a sole proprietor. You don't actually need a DBA. DBAs are really tricky because the Office of Professions should still be approving that assumed name. A DBA, for people who don't know, is a doing business as. So it's like a, professional name that you are operating your business as, even though it's not like a separate legal entity. It's you as an individual operating under this assumed name. In New York, it's called too, a DBA. And yes, you can operate as a sole proprietor.
Okay, another question is, do you need to add on to liability policy for telehealth? Also, if a patient moved to another state and during transition to finding a therapist, the patient travels to New York for a day, can the patient be seen for telehealth or office session?
If someone is, I'm going to go backwards because it's easier for me. If someone is physically located in New York, you can see them. And that's like not a question. So if they're in this transition period and they're coming back and forth to New York and you see them when they're in New York, that's appropriate. There may be issues and there may be some amount of continuity of care where you can see people while they're in the other state, while they're in this kind of in-between phase, let's say in particular before they've made this like permanent switch to the other state. And then I'm sorry, what was the first part again? I just
The
lost it.
the first part of the question was, do you need an add-on to liability policy
Oh,
for telehealth?
right. So generally, no, but there might be an issue where you want to get like cyber security insurance in case there's like a data breach or something like that. But it is important for you to check your own policy and make sure that it covers not just in-person sessions, but telehealth as well. It shouldn't be an add-on, but that is really a question for your particular policy if they had a carve out.
Okay. Another question is, would this process be very different if you wanted to co-own a business with another practitioner or create a cooperative?
Cooperative is a really tricky situation, and that is like its own whole conversation that I definitely encourage people to speak with an attorney about specifically. I don't actually handle cooperatives. I should also say I handle small practices. Most of my clients are individuals or have a small group practice. I kind of like cut it at like 20 employees would be kind of my limit. So a cooperative is something a little bit bigger than I deal with. Same with MSOs, management service organizations. So for that individual with the co-op, you should look into that. For others who are going into practice with one other person or a couple other people, generally, yes, this follows the same course, but of course, it gets much more complicated. When you form your entity, whether it's a PLLC or a PC, you have in a PLLC, it's an operating agreement. In a PC, it's bylaws. These are like the internal governance, rules that you set for yourself. And that is just so important that that gets very thoughtfully hammered out. So, like for a PLLC, your operating agreement governs how ownership works and how management works, how decisions are made, how you distribute money to yourself, and that kind of thing. And you can imagine if you're going into business with somebody else, you want to be very, very clear about how all of these things are happening. But no, like generally, like the guidance on my website and stuff, that is for, a single owner or a multi-owner entity, business, PLLC, practice, all the words.
Thank you. We have a couple more questions.
Yep.
Can you discuss confidential HIPAA compliant payment options?
Oof. This is a really good thing for person-centered tech who stays on top of these different service providers that are coming up and they vet them and that kind of thing. But, the general idea is with any third party that you're dealing with, whether it's an independent contractor or like one of these EMRs or billing services, that you're supposed to have a business associate agreement between the two of you. A business associate agreement covers like HIPAA requirements and is essentially saying that this other party will follow like your rules of confidentiality and be thoughtful about the rules that HIPAA dictates. So that's like a like absolute baseline thing as you go into that, like where this stands. I will actually just say a quick caveat that I did just catch something recently. Like there was a carve out for certain payment programs that I still need to look into. It just like I don't know. I happened upon it last week and I haven't dug into it yet. So I'm sorry if that person or wants to reach out to me or other people have questions about that. I'm going to update that though. I'll put it on my in this guide for common issues. Yeah,
Uh,
thanks for the reminder of that. It was
uh,
added to a fairly long list of things to get
Absolutely.
to.
We'll make sure the attendees get access if they have any further questions. We do have another handful of questions within the last 10 minutes of the event.
Okay.
Elizabeth Dennis, I'm considering doing evaluations in private practice rather than therapy. Would a PLLC still be needed or sole proprietor?
You want to you're moving into your own private practice and you're going to continue seeing clients. I'm just making sure I heard it properly. And you're wondering if you can be a sole proprietor or a PLLC. You can be either. When you're a sole proprietor, you do not have the same protections that an LLC, a PLLC in particular, provides, namely protecting your personal assets from the debts and obligations of the company. So really protecting your cash, your home, whatever it might be, property you own, in case something happens, in case there's conflict with the business and another party.
Can you clarify what you mean by an LCSW not being able to provide clinical services under scope of practice? Is this in reference to, say, specific testing that a psychologist would do?
Yeah, exactly. There's certain things that like would be outside the scope in terms of weighing in on medications would be like the most specific thing, right? Um, So, like medications, physical things that people might be doing with their body, things that they might be ingesting, their diet, and these types of things are outside the scope. I think your reference was like psychological evaluations. There is a certain amount of evaluations that you can do, and then there are limits to that as well of what, is more for a psychologist to do. It depends on the circumstances. It depends on what like the requirement is for that evaluation. You can't just be like, yeah, um, essentially going beyond the scope of what your practice allows. Sorry, that's a very vague answer, but it's so specific to the circumstances.
Can you advise on any potential issues with transferring of private practice from New York State to South Carolina?
For transferring, I guess the idea is that this person is no longer going to be seeing, I'm sorry, it was New York to North Carolina, would
South
no
Carolina.
longer, to South Carolina, sorry. This person would no longer be seeing New York clients and would exclusively work with South Carolina. And you formed a business entity in New York and you're doing a transfer. There is some mechanism in certain states. I can't speak to what South Carolina has for it's considered domestication. So you like change the like primary place of the business. Oftentimes this might be kind of clunky and it might be easier to start the South Carolina practice and then shut down the New York. But I understand why like also that sounds annoying too. That's going to be really specific to each person in each scenario. Um, So that one I would consult specifically with someone on. There is a mechanism in some states. New York does not have that mechanism. That's where I'm actually like, gotta check. Like, who knows what South Carolina does?
Okay. There was some clarification from Rachel as a sole proprietor, she meant.
I'm
Um,
sorry, and what remind me, this was
that's the last question. Can you advise on transferring a private practice?
oh, okay. Yeah, so when you're a sole proprietor, you're just kind of get up and going. You might get an EIN as a sole proprietor. You should get an EIN as a sole proprietor. And I don't know, there's not a whole lot. You have contracts, agreements, regulations that you're following that are specific to New York. You have to make sure you're following South Carolina's for how your practice is governed, that you have the proper client documents and all the required language in those documents. But in terms of like, I mean, you might reach out to your EMR, you might reach out to your malpractice insurance carrier. I'm trying to think what else where it might matter that you've moved, but you at any point can operate as a sole proprietor in any state that you are licensed in. Some states might have requirements that you are supposed to register as an individual, but generally it shouldn't be a lot of uh, like work at the front to get things set up with the
Okay.
state.
We have time for just another question or so. Is it advisable to have a PLLC in place before meeting with the self-pay client?
I'm always going to recommend that someone has a PLLC. I think it's helpful at the beginning when you start your practice because it's giving you this protection off the bat. Um, and there's just different directions your practice might go. You're in this state of like getting everything in order early on. So to me, it makes sense to do everything in the name of this practice. It can be a little tricky to make the transition. It's not the end of the world to switch from a sole proprietorship to a PLLC. It's like administrative stuff. But to me, you're already doing it and you're in that headspace. You're providing yourself with this extra protection. You're affording yourself more options in terms of benefits and like a tax um, in the space of tax. So I guess my overall thing is you can see somebody who's self-pay. You can see someone who's paying with insurance as a sole proprietor. But I think it's important to weigh what your specific plans are and whether, it makes sense to reduce your exposure to liability, your personal exposure to liability by creating this other entity that now gives you these protections.
How hard is it to close a business, a PLLC? In the business will, can one who starts it have a plan for removing oneself?
If you're the individual person and you're shutting it down, it makes sense. There's a, not particularly complicated process in New York for shutting down your PLLC. Your PC is a bit more complicated. But your PLLC, essentially you wind things up, it's called, and you pay off your debts. You remove money from the bank accounts, you clear up all your contracts, you shut everything down, and then you file papers, articles of dissolution with New York State. And it is pretty simple. If something happens to you, you put it in your professional will, like some instructions for the people who are going to take over for what the process would be for you to shut things down, for them to shut things down.
If licensed in 3 states and working for a company like Headway as a 1099, they have a national contract. Do you still need the same protections with the PLLC?
This is a very complicated question, and I absolutely would encourage people to take this on an individual basis. These companies operate in different ways. There's questions about how they're operating and whether it's appropriate for you to be treated as an independent contractor or not, particularly in New York State. And I do think that it makes sense in a lot of situations that someone would have a PLLC to afford themselves these different protections in case there was a dispute between you and this business now that you're dealing with, this like mental health platform like Headway.
Okay, we have time for one more question. For dual state licensed practitioners in private practice in both New York and New Jersey, do two PLLCs make more sense than a foreign PLLC?
I don't think so. I think this makes it more complicated when you have two entities, then you have two bank accounts, two credit cards, everything. You're not combining these things. Like, I don't even know what would happen with your EHR if, like, you're doing everything in the name of the business. That's what like gives you these protections. So if you have two, it just gets so clunky. There may be reasons why it would make sense based on someone's individual circumstances, but for the most part, I'm like not likely to see it that way.
Okay, I think we only have one last question. Should I use the EIN with the PLLC? Is it a must?
If you get a PLLC, you absolutely should get an EIN in the name of the PLLC. Yes. When you're a sole proprietor, you should get an EIN as a sole proprietor. You can also
Excellent.
use that sole proprietor EIN in certain situations when you also have the PLLC and the PLLC EIN.
Excellent. Thank you so much, for your time and the information. It was such a thorough lineup of resources for folks. Everyone that's in attendance today will receive all of the resources that Dan Pepitone has shared with us, as well as contact information if you have further questions and things like that. Once again, thank you so much, Dan. Thank you to Joshua, our live captioner for the day. We appreciate your time and we hope to see you again.
Thank you.
Thank you all. Have a great day.